All right, so I'm so glad that you are all here and I'm grateful for you. Before we begin, I really want to acknowledge something that's up front here. Estate planning is not a topic people are excited to talk about. Most of the time, clients come to me, they really don't want to talk about death. They feel uncomfortable. It feels really heavy. All of these decisions feel so big to them, and they really just don't know where to start. But when we frame it correctly, estate planning is actually a conversation about love, responsibility, and faith. Okay. So tonight we're not talking a ton about documents or legal jargon, and we're looking at one simple question for us. What is the legacy that we will intentionally leave behind? Okay. And of course, now we're not going. There we go. So, why does this conversation matter? Estate planning is actually an act of stewardship. So we always want to look at the fact that everything that we own is from God, and it is our responsibility to take care of it and manage it to the best way possible. Estate planning is also a gift to our families and our faith community. It allows us to have intention when it comes to our division of assets, both giving to our family and our loved ones. And it allows us to make sure that we are leaving the gifts to the faith communities that we love in the way that we want. And we want to plan with intention, not fear. When we are planning at the last minute because we are ill and we are afraid of what is coming and how quickly that's coming, the plan is not done as well as when we can sit down and really think about our assets and how we want those things divided and who we want our assets shared with. Okay. So I want to remind everyone that this is really about faith and our legacy. So all of our assets, we are stewardships of them. We might think that we own them, but God gave us those things, and we are really reminded that the earth is the Lord's and everything in it is the Lord's. So everything we have, our time, our resources, our wealth, has been entrusted to us for a season. And estate planning is that final act of that stewardship. It's not about planning for death, it's about planning for the people and the causes that you care about while we are able to guide that outcome. Okay. A well crafted estate plan allows us to give gifts to our family. It's a protection against conflict for our family. And it's also a reflection of our faith and values. It's a meaningful way to support church and the ministries that we believe in. It allows us to be generous beyond our lifetimes through legacy gifts and other things. What is the cost of no plan? That's something that I talk with a lot about people. I talk to a lot of people about. So what happens when you don't have a plan is the state of Michigan has intestacy laws. What that means is that if you had no will or anything else, you've died intestate, and the court in the state of Michigan decides how everything will be distributed. So the court is making that decision instead of the family. You will be in probate court in order to manage that distribution, which causes delays, expense, and a lot of uncertainty. It can also cause unnecessary family stress and conflict. When your wishes aren't written down and people are trying to guess what you wanted, especially through the lens of grief, it makes life a little bit harder. Okay. What are the core documents of an estate plan? We always plan for incapacity. Please take this home with you that incapacity planning is recommended for everyone over the age of 18. It allows people to make decisions for you when you are incapacitated or when you can't participate in those. So we have powers of attorney for finances that allows someone that you trust to manage your money and your assets. And then in Michigan, we have a patient advocate designation. That patient advocate designation allows someone that you trust to make medical decisions for you when you cannot participate in them. These incapacity planning documents, they die when you die. Okay. So when someone comes to you and says, oh, I've been a power of attorney, but mom died last month, You no longer have access through any of her things through that power of attorney. Okay. So then up next, we can talk about wills. There is this whole idea that you have a will so you can avoid probate court. There is nothing further from the truth on that one. Okay. So what a will really does is it answers the question of who receives what and who's in charge of making sure that gets distributed. But the person that has the ability to transfer those assets is done through a document that is obtained by the court called letters of authority. So you can have a will, but there's no authority to do anything until you open up a court case. Okay. Wills are still important to have. They allow us to go ahead and manage that distribution, and we have that mechanism in place, but you still have to utilize probate court. Most of the time, that is what people don't fully realize. Okay. We also regularly manage assets with trusts. People think that you need to have a lot of money to have a trust. That is simply not true. If you have minor children, if you own real property, and if you desire to leave things to people in a somewhat unconventional way, you need to have a trust. Okay. You don't have to have those. And if you have minor children, you need a trust. If you have real property, I highly suggest that you have a trust. If you want to leave things to people in an unconventional way, I highly suggest that you have a trust. Yesterday, I wrote a trust for someone who is dying. She's in her 50s. And what she really wants to do is have her trustee give money to all of her friends to take trips with her loved ones. She said, "Can I do that?" I said, "Of course you can." So we set it up that way so that she can make sure that her wishes are being followed. That's the beauty of having a trust. I remind my clients to think of the trust like a bucket, and we put all of your assets in it. And while you're alive, you're in charge of your bucket. It's great. When you become incapacitated or when you pass away, the person that's listed as your successor trustee is the one that's now in charge of that bucket. And they have the ability through your trust documents to have authority over all of those assets that are in the trust. And then they can distribute those assets pursuant to the wishes that we put in your trust. The biggest deal is that we want to make sure that we put items in your homes, your properties, your financial assets into the trust so they can be managed. If they are still in your own name when you pass away, guess what? Now they're not in the trust, and we have to use something else to go ahead and put those into the trust later on. So you may have heard the term funding the trust. All right, that's what that means. When we're transferring your house into your trust, we're funding it. When we are putting bank accounts and other financial assets into your trust, we're funding that trust. You need things titled into the trust in order for us to distribute them through the trust. So then people ask me, well, what happens if we didn't put the stuff in the trust? What if we didn't fund it? Well, then we go back to that will. Okay. So the will still allows us then to put items into your trust for that distribution. But our hope is we never have to utilize a will if you have a trust. Okay. So there are ways that we can fund that trust after death, but it is so much better to fund it while you are still alive. The other core estate planning tool that a lot of people forget about are beneficiary designations. Every bank account that you have, every investment, let me pause, not every investment. So like Acorns and some of those other online little apps that help you invest money, Robinhood, they don't have beneficiary designations on them. So if you have them, think about maybe adding a co-owner to those. But everything else that you have, from your bank accounts to your insurance policies, your life insurance policies, your investment accounts, your mutual funds, your IRAs, all of those things have beneficiary designations on them. If you list someone or something, right? So if you list your church as a beneficiary, when you pass away, that will pass on to those people that are listed in your beneficiary designations without going through either the probate court or your trust. Does that make sense? Kind of? Okay. So ultimately, that's why we add beneficiary designations in as a core planning tool. These documents are not at all about pessimism. These documents are about peace of mind, so that you know if you happen to be in a car accident, what's going to happen, who's in charge. If you happen to pass away, your loved ones know what's going to happen and who's in charge. It helps with that clarity. Up next is a legacy beyond our assets. So we have all this money and we have these items that we want to pass along to people, but our legacy is so much more than having just our assets there. Our legacy is our faith and our values. That's why we encourage people to show their faith through where they give, right? There's this whole idea that your values follow your checkbook, right? Wherever your money goes is where your values are. And so by making sure that we include our congregation and the church in general as part of our legacy and part of our estate plan, that's how we can show what our values were. We also can show our faith and values by sharing our love and guidance for all of our loved ones. We have offered them guidance as children have grown up. We have given them advice when it comes to schooling and career and life and relationships and all of those things. And they have taught us so much, right? So our story continues in that love and guidance. Sometimes people write letters to their loved ones as part of their estate plan, so that when they pass away, they find it in their estate planning binder and they know it's there, which is a wonderful way to leave a message for people. You're also leaving that story that continues. In my practice, we encourage our clients to complete what we call the story project. I have this goal to have all of my clients record all of these videos that talk about their stories about how they met their spouses or why they chose the career that they did or the most memorable thing that they did in their life, all sorts of things, because it matters to hear their story and have their voice. This all started for me because of my grandmother, my Oma. I know that I've told people before that part of my passion for legacy giving and supporting the church comes from the fact that my father was a World War II refugee from Germany, and he immigrated to the United States in the 50s. And he immigrated solely because of the church. Lutheran World Relief invited immigrants, and they all applied, and they just placed them all over. So because of that, we had my grandparents here and my dad and his two brothers. My grandfather died long before I was born, and my grandmother didn't talk a lot. She didn't tell us a lot about her stories. When I was 17 years old, I went to her house for spring break to learn how to knit, because she would knit the German way, not the American way. And you know what? I don't even remember the knitting at all. I haven't knit in the last 40 years. It doesn't matter. But my grandmother during that trip told me about her life in Germany. I was 17 and I didn't write it down. My grandmother died when I was 38 years old, and she never talked about it again because she just didn't feel that comfortable doing it. And I really wish I would have written that down. So your legacy has to do with those stories, and those stories include the church too. I promise you, especially if you're including them in your legacy plan. That's why it's so important to make sure you write down those stories. Okay, so we have charitable giving and the church. How do we actually make lasting impact with our charitable gifts to the church? So we give planned gifts. We can do that by having a beneficiary designation on certain investment accounts. There is this saying that you want to have the best beneficiary for the best account. And sometimes giving certain accounts to a charity, such as your congregation or the diocese or whatever you decide to do, will have a tax implication as well, because you're giving to a tax-free organization, right? And so we want to make sure that we have certain things that are going to the church, and then they will have that lasting impact in the church because of where you're giving it to and how the church is using it. Sometimes our congregation will have an endowment fund, And they have a direction that says that we know that this much money is going into an endowment, right? Whatever we get in a bequest will go into the endowment, which will be used for the future of the church and the future of mission work, which is a wonderful way to have a lasting impact with your own planned gift. Okay. It also allows us to support our ministry beyond our lifetime. If we are giving something, such as to an endowment fund, or you can set up a charitable annuity, which would be giving interest and other things to your congregation for a certain length of time, right? You can do all of those things so that you can make sure that the church is getting money for years to come from your gift, long after you've lived. And what a way to make a legacy there. How fabulous to know that your planned gift through your estate plan will be able to support a music ministry or a children's ministry or even a pastor. I tell a story that I had one congregation that they set up an endowment fund for the goal of having it support one full-time pastor and their salary for years to come. What a wonderful way to really secure the future of that church. So you can support that ministry long beyond your lifetime by making the right choices in meeting with professionals to help you plan to make that gift. It also allows us to align our faith and our finances. Remember how where our money goes, that's where our heart is. And so making sure that we still have our faith included in our finances, even in death, is a fabulous way to have everything taken care of. Okay. We also get to protect family unity. It happens every day. You know, parents die and kids go, no, they wanted this. And other family members say, oh no, they really wanted this. And it seems to me that the less stuff there is to fight about, the more fighting that there is. And so having clear intentions in your planning can help prevent conflict between siblings and everything else. Siblings, loved ones, it gets to be messy. Oftentimes I will meet with clients and they will feel like they have to put their children in age order for who's in charge. And sometimes the oldest is not always the best choice. Sometimes there's a person that you know that has more experience or has more time, or you have a child that is a little bit more even-keeled than the other ones. We all know that our children have all these different personalities, and making sure that we have the right person in the right job can also help prevent that conflict. We also remind our clients that fairness is not always equality. So you may want to leave every child the same amount of money, but it doesn't mean that it's an equal impact on their life. We might want to leave 20% of our estate to a congregation, but we might want to really think about if it's going to a congregation or another nonprofit that you love. Our hope is always congregations because they continue going on, but I'll get clients that want to share it between St. Jude Research Hospital and their congregation, which is a wonderful gift, but perhaps we don't share that amount equally, right? Perhaps we give a little bit more to the congregation and a little bit less to St. Jude, or you can figure out a way that makes the most sense to you and your family. So by planning, we get to protect that as well. Estate planning also offers peace of mind for those that you love. I know that by having a power of attorney and everything else in place for me, that my family knows what to do when something happens to me, both if I get incapacitated or if I pass away, which is so important to do. You also know that you're not going to have to go through the probate court process because everything was taken care of. You have a trusted advisor to go talk to about the distribution of assets and really what comes next. Because when a death happens, we remind our clients that you have to grieve first. Nothing is an actual emergency. So go grieve, and then we can come about and talk about what's next in that process to make sure things get distributed properly. So what are your next steps? This is one of those things that people go, great, I learned about this. I know that I need to have documents. I know that I have the ability to protect my family by having these documents in place. And I know that I can follow my heart and leave my legacy by supporting my congregation through a bequest and making sure that my values are lived out. But they don't know where to go next. I encourage you to find an attorney that you would like to work with and have a consultation with them so that you can talk about what's important to you and what they think. And don't just choose any old attorney. Interview them until you're comfortable with them. Because some attorneys aren't quite as philanthropically focused. Some attorneys do estate planning on the side. Just keep meeting with people until you feel aligned with them and that they are there for your values. I also encourage you to sit down and talk to your loved ones, your spouse, and even your family about what your values are and how you want to have your assets divided. Do you want your memorial gifts to go to your congregation? My dad recently passed away and his memorial gifts went to Lutheran World Relief, the organization that sponsored their immigration, because it was important to us. His memorial gifts also went to our All Saints Lutheran Church Benevolence Fund, which supports worldwide mission. And it was important to him to have benevolence. So we chose what was important to him because he told us, and we knew that. So reflect on your values, write things down. What are the organizations that you really want to have supported? Begin the conversation. I get on my soapbox about this one a lot. Please talk to your loved ones about how you want to be treated at the end of your life. You're asking them to make hard decisions for you. And if you can't participate in those decisions, they need to know how you want to be treated. It makes that so much easier. It's also important to record those stories. Tell everyone what was important in your life. There are books out there that says, when I die, right, this is going to happen. Or interview your grandparent. There's all sorts of books like that. I would encourage you to start that process as well. And then you should really create clarity for everyone, for the people that you love and what's there. And by creating that clarity, you're going to have everything written down through your estate plan documents, through what we call a cherish letter that says, these are the things that I have and this is what's going to happen to them. Okay. Is it true? I have a question here. Is it a true gift to them when the time comes? Oh, it's a true gift. Sorry, it's a statement. I can read it. I promise. It's a true gift to them when the time comes, as it can be very stressful to the kids when they have to guess and worry if they're making the right choices for you. And that's when you have those end of life decisions, right? If you have to decide, would we continue to have treatment or not, right? That's where it's so important to have those conversations. So create that clarity though about what you want to have to happen with your stuff and write it down in some way or another. It will help all of your loved ones know what's going on. So you have a bit of extra credit though. And I challenge you all to do this. It's fairly early in the year yet. Create a list of every account that you own. It can be a handwritten list. It can be in a Word document. It can be an Excel spreadsheet or whatever it is. Write down the institution, the owner of the account. Sometimes it's a joint account. Sometimes it's not. The account number and the beneficiary. You're going to find that there's some accounts that have beneficiaries that are minor children. It's a bad idea. Make sure that you have something else in place other than minor children. You will find that some accounts have beneficiaries listed who have passed away. Also a bad idea. And every once in a while, you'll find other accounts that have a complete beneficiary that you don't know, because financial institutions make mistakes and keystroke errors and all of those things. And I encourage you to update that list on an annual basis. Look at those beneficiary designations on a day that you will remember. It can be an anniversary, a birthday, New Year's, the start of the second quarter, whatever works for you, so that you will make sure that you're looking into that on a regular basis. Because life changes, you will have people pass away, you will have, unfortunately, sometimes divorce that happens, all of those bits that happen that you want to still make sure that those beneficiaries align. Okay. And by making that list, you're going to help everybody. And then you're going to put it in a death drawer. I know. I told you I wasn't going to be morbid, and here I am morbidly talking about death drawers. But it's really important that your loved ones know where to find your documents and all of your stuff. I spend so much time helping clients find assets, and they think that I can just put in a social security number and this big giant list will pop up. It doesn't work that way, folks. So, when you call a financial institution, you say, hi, I'm calling because I know that Chris Harris passed away and this is a social security number. Do you happen to have an account for him? And they will say, if we do, we will send it to the last known address. And I promise you that phone call does not take those 30 seconds. It takes about 25 minutes. And then you wait for weeks, and maybe you get something and maybe you don't. So help your loved ones by having that list there and putting it in the death drawer. And then when you receive your estate planning documents or whatever you decide to set up at that point, you can also put it in the death drawer so that people know. I get phone calls that say, I know you did mom's will. Do you have any idea where it is? I did. That she has a trust and it's in a blue binder and it's about this big and this is what it looks like. That really helps them find it. But what it would have been better is if mom said, I have estate planning documents and a list of all my accounts, and it's in the death drawer, which is the bottom drawer of the filing cabinet in my office. Or it's in the lockbox that's in the basement. Or in my household, I have mom and dad's lockbox, my grandparents' lockbox, and my lockbox. They're all lined up in a row and they're all the same lockbox. But it's a fabulous thing to have, and it's a great way to help your loved ones know what's there. So estate planning is not about fear. It's about planning with intention. It allows us to include the people that we love and the places and organizations that we love. If we don't do proper planning, we can't include the places and the organizations, which is the biggest downfall. Okay. And we flew right through this. You can tell that I wasn't getting questions bombarded at me, which is what usually happens, which is because I usually do this in person. If you have any questions, you can always reach out to me, but we can always also have some questions here, and I'm happy to answer them. But you can reach out through email or a phone call, and I'm happy to have the conversation because it's important. And just because you call me doesn't mean you have to have me draft documents either. I'm happy to, but that's not what we're here for. We're here to make sure that everyone has the education that they need to make estate planning a little bit scary and give you an opportunity to give to the people that you love. And that's it for me.
Sonia, thank you. That was wonderful. I did have a question as you were going, or maybe it's just an opportunity to expand a little bit. I really appreciate what you were saying about the value of clarity and communication with your heirs, with your children, with your family. I used to, one of the attorneys in my office used to do a lot of probate law, and it invariably was about family members in a conflict because they were very surprised at some of the decisions that were made. Do you have any advice for families on how they can kind of talk about their decisions early on, so that there's not they can reduce the amount of conflict and confusion and anger that may happen later on? Do you know what I'm talking about?
I do. Um, so you have some families that are very conflict avoidant and some families that are really kind of put up those walls. If you have the type of family that can have these conversations, when you're sitting down and celebrating a holiday, when nobody wants to do the dishes, sit down and talk about, oh, hey, I met with my estate planning lawyer and this is what we decided to do, right? We really thought about it and we went through and we know how much money we have and we know how much debt you guys have, right? Or we know which organizations we really want to support. And this is the reasoning that we had behind our decisions. We want you guys to know that these were our sole decisions. I also regularly encourage my clients to write letters. You can write letters and leave them in your estate plan binder that tells your children why you made the choices that you made. Because I can sit there and write it all out, but they think that I did it or that I had a lot of, a lot of input into it. Versus usually they say, I want these 5 things. I go, great. And I ask them for clarity that they never really thought about. But honestly, sitting down and telling them and having that conversation about why you decided it will help reduce that conflict later on and help them not think that the person you appointed is the one that's really making those decisions, because they are not at all. They are there to enforce those decisions. So we do have a few questions here in the chat. Is there a time that a trust should or can remain open after the owner dies? So it's called the grantor of the trust, essentially, or the trust maker. There's all these different words there. But when they pass away, it will take a minimum of 6 to 9 months to even settle it and distribute the assets after they pass away. Sometimes it will take 20 or 30 years. Let's say that I'm giving money to someone who is 4 years old now, and they're not going to receive that asset finally until they're 35. That trust has to live on for 30 years. And under the law, the trust is kind of like a person. Okay, so the trust will get a trust identification number, which is like a social security number for the trust. And it will pay taxes and it will do all of those things. And the trustee will be managing that money until the final distribution comes. And so ultimately, the time that the trust is open after the grantor passes away is really dependent on the assets and the distribution. You have to publish, and whenever claims come in, and those have to be paid, and you have to file the last taxes for the person that died, and you have to file the taxes of the trust. So it just takes time. And I encourage all trustees to not rush through that process. Because if they rush through that process and they distribute all the money and then a bill comes in, then either they're paying for it out of their own pocket or they're asking everyone else to give back money, which is not easy. Oh, hey, I just gave you $100,000, but you know what? I need 25 back. Nobody wants to do that. So it just takes a while to come up and make sure that everything is distributed in the proper way. Did that answer your question? Okay, we're going to keep going. The next one is, what is the best way to deal with online accounts and passwords after death? Okay, so there's a few things. There are online programs like LastPass, where you can basically appoint someone who is in charge and can prove that you've died, and they will then open up all the passwords to you. You can do what a lot of us do and keep a password book, okay? Or do what a lot of us do and save all of our passwords on our device, and then we make sure a loved one knows how to get into the device. But ultimately, it's making sure that your loved ones know where to find it or how to deal with it. I personally use LastPass. For my parents, I happen to know how to get into every single one of their accounts. And then I've left a spreadsheet that is locked for my sisters to get into, because my sisters don't know how to get into all of their things, but I do. And so it's basically either leaving a list or using an online program. LastPass is my favorite for now. There could be others, and there's a fee that you pay, but it's kind of worth it to get into everything. Does a trust have to file income taxes? They do. So we as individuals in the United States file 1040 returns, okay? A trust and an estate return is a 1041 form. So when you have to open up someone's estate through probate court, they file taxes. When you have a trust, they also file taxes. Depending on the type of income that the asset has, that the trust has, and the source of the property, the taxes are different. And this is where I remind people that I am an estate planning attorney, not a tax attorney or a tax preparer. So I know enough to be really dangerous. So you'll need to actually talk to your tax professional about it. But I highly suggest that if you are a trustee or a personal representative of an estate, that you pay someone to prepare those tax returns. They can be a little bit complex, and they can make sure that you are paying appropriate taxes, but not too much in taxes, and that you won't be personally liable for that later on. Okay. And then, is there a particular directory of estate planning attorneys that I recommend? There really isn't one. Okay. So what will happen is that you will have like senior associations and things like that within your counties or your communities, often like a adult senior centers, those types of things. And they will have some attorneys that they recommend. But typically those attorneys are the ones that will offer free services for people. And people who usually when they are offering free services, it's because they don't have enough paying clients to do that. I offer free services to people out of the goodness of my heart, but I limit that to about 3 people per year. And if I were to volunteer my time at a senior center, I would not get any of that back, right? There's way too much time there. Unfortunately, there's not just this big directory. You can go to the State Bar of Michigan and look for an estate planning attorney near you. But again, those are attorneys that are paying to be a part of the lawyer finding service. Okay. And
If I could say it, Sonia, the Legacy Giving Task Force for the Diocese of Michigan, we are in the process of putting together such a referral list as well. And I can tell everyone on this call, Sonia is #1 on that list. But you can reach out to me and I will be glad to refer you to others as well.
yep. And so for me, that's where I really encourage people to sit down with a multitude of attorneys and not choose the first one unless you're so incredibly comfortable that you're like, nope, this is it. If you have any doubt at all, move on to the next one. Okay. Is there a rule of thumb for when you should have a trust versus a will, or is a trust always preferable? A trust is always preferable. So whenever you have a will is a list of instructions to the court about who is in charge and how things will be distributed. But the authority to transfer any assets at all lie with the probate court. So you can sit there and say, a lot of people still use the word executor, but that word fell out of Michigan law about 30 years ago. So people will sit there and say, oh, I'm the executor, I'm the personal representative, I get to do X, Y, Z. But they have zero authority until you go through that court process to open up the estate and have letters of authority there. When you have a trust, by virtue of your trust agreement, which is really what that whole big trust document is called, is a trust agreement. By virtue of that agreement, you have said, I am in charge of the stuff that's named in this trust while I'm alive, and when I pass away or I'm incapacitated, this is who's in charge next. Their authority lies within that trust agreement, and you don't need a court order. So for me, if you have anything beyond having beneficiary designations on things, so if you own real property at all, or if you have a little bit more complexity than having 2 children, where you rent an apartment, you have 2 children, and you have 1 vehicle and some money in the bank, you should have a trust set up. It allows you to plan for all sorts of contingencies. Contingencies for, I want things to go to these children, but if one of them predeceases me, then what? Okay. And if one of them is now disabled and giving them money would interfere with government and federal benefits, right? We get to plan for all sorts of contingencies like that. Versus a will does not allow you that flexibility and that ability to plan without utilizing the probate court. So for a majority of my clients, I mean, we have options to avoid probate court, but it doesn't have the ability to have those contingency plans in place, and it's not quite as evergreen. And so the other thing I really want to touch upon is that estate plans are never set it and forget it. They regularly need to be reviewed and updated. You want to make sure that everyone that you have listed are still people you know, like, and trust. It's amazing to me the amount of people that will put their neighbors as guardians of their children in their will. And then the neighbors move away. And then you don't know the neighbors anymore. And then we really need to update those. They will also list children and their spouses, and then their kids get divorced, and now the in-laws are the outlaws. And we just want to make sure everything is the way that you really want it to be. So estate plans should be reviewed at minimum every 5 years. I try to get my clients to sit down with me every 3 years, because then number one, we get to say, hey, how's it going? But then we also just need to, we can make sure that what they think is a big deal, right? A daughter got married versus what I think is a big deal, that you've been diagnosed with Alzheimer's, gets handled in the most appropriate way. Do we have anything else in our chat?
Any other questions, friends? Otherwise,
Thank you.
thank you, Sonia. Again, that was really wonderful. And she is one of our resources. And so reach out to us if you'd like to get some referrals for estate planning attorneys. In a couple of weeks, on February 26th, on Thursday, again, same time, 7 o'clock, we'll be having the second of these webinars. This is going to be called Plan Giving 101, and it's going to be offered by a certified financial planner, Tom Post, who also is a part of our Legacy Giving team. And he's going to be talking about more of the financial side of this and some of the more creative ways that you can leave a legacy, whether it's for your church or for any of the various causes in your life that are important. So join us on February 26th. And I think maybe Dennis, if you could put the link into the chat, that would be great. Other than that, I think I see lots of thank yous and lots of well dones, Sonia. So thank you very much.
Very much.
All right. God bless you, friends, and have a good evening. We'll see you next time.